welcome to this inaugural session of the Young MCIA's India Arbitration Talks, a webinar that is designed to or intended to bring together the Indian arbitration community to discuss relevant themes about arbitration in or related to India. My name is Dilber. I'm a senior associate in the litigation and arbitration department at the law offices of Homburger in Zurich, and I'm also a member of the steering committee of the Young MCIA. Before I introduce our topic and the speakers for today, I just had one housekeeping matter. This session will be recorded, so participants are free to leave their cameras on or off as you prefer. So let me give you a quick overview of today's topic and why we chose this topic for this inaugural session today. As you have seen, today's topic is on recent reform initiatives of the Indian Arbitration Act. What still needs to change? Now, the word still in that topic is quite key today. Because for anyone who's been working in the field of Indian arbitration, in India or with India, you couldn't have been oblivious to the number of recent reform and amendments that have been passed by the legislator to the Indian Arbitration and Conciliation Act of 1996, which is the base act of arbitration in India. So we started off with the 2015 amendment, which was, I think, hailed to be a step in the right direction, very pro-arbitration reform. Closely, that was followed by the 2019 amendment, and then we had the 2021 amendment again, which maybe left people a bit more skeptical. All these amendments were, of course, projected as required to make India an arbitration-friendly jurisdiction, or an arbitration hub, as some people like to call it. Now, one could have hoped that through these amendments, quite a few, 3 in a span of 6 years, the legislator would have reached or achieved what they had sought out to do. Yet, one might have been surprised or puzzled to see that in the middle of this year, so June 2023, the Department of Legal Affairs in India published a notice, which was a request for comments from stakeholders on the working of arbitration in the country, the arbitration law in the country, and the need for reform. So when I saw this notice, my first question was, the first question that cropped up into my mind was, why after 3 comprehensive reforms, amendments, is the Law Ministry still looking for information, still looking for suggestions to improve the arbitration ecosystem in India, as it has said? And more importantly, what needs to still change in India to achieve this goal that the legislator has set out? So if you have the same doubts or questions in your mind, then I'm very glad to say that you're in the right place, because we have with us today 2 very eminent arbitration practitioners who will shed some light on this question. And it's my absolute pleasure to introduce our 2 panelists for this session. I'll start with the lady because she's also on the top right hand of my screen. So Shaneen Parikh is a partner at Cyril, Amarchand, Mangaldas, a leading Indian law firm. Shaneen heads the International Arbitration Department at the firm and has over 20 years of experience in arbitration, both in India and abroad, as well as in arbitration-related litigation. We also have with us Mr. Darius Khambata, who is a senior advocate at the Bombay High Court and a member of one Essex court in Singapore and London. Mr. Khambata has appeared in countless important constitutional, commercial, and administrative law matters. But what really interests us here today is his experience, which is just as extensive in international arbitration or Indian arbitrations, both before arbitral tribunals in India and abroad, as well as arbitration-related litigation before the Indian court. Mr. Khambata is a member of the SIAC court, and he was also a vice president of the LCIA court. So we're really fortunate to have with us today these 2 speakers who breathe arbitration in and out every day and can really explain to us what still needs to change in India. I'll turn to you, Shaneen. Imagine that you are sitting before this reform committee, this expert committee that has asked for consultation. You have 12 minutes. What are your recommendations to this community? What needs to be done to improve the overall arbitration ecosystem in India?
Thanks, Dilber, and thanks to all you young MCIA committee members who've invited me. I'm delighted to be here today. Plunging straight into it. Yes, Dilber, you noted that we've already have 3 sets of amendments since 1996, when our entire arbitration regime was completely overhauled. So the terms of reference, if you look at the notice, are really carte blanche. But our act is modeled on the model law. It has gone through 3 considered amendments. I think today it is fairly robust. And although the terms of reference seem to be carte blanche, I think we should be very careful that the amendments are not overly prescriptive. We have to keep in mind, as Justice Nariman said in the Supreme Court, that party autonomy is the brooding and guiding spirit of arbitration. And therefore, there must be room left to the stakeholders to really take the arbitration where they want to go. Therefore, I don't think, and I think we should be very careful not to over-egg the pudding, as it were. So that said, there are some amendments that I think do need to be put in place. I'm going to touch upon a couple of amendments in the Arbitration Act itself, but a couple of things that I think may need to be done to make India truly an arbitration-friendly jurisdiction. From the perspective of the Act, you had both the Law Commission of India in its report in 2014 and the high-level committee recommending amendments to ensure that emergency arbitration was brought into the purview of the Act and that emergency awards were enforceable. Now, unfortunately, these suggestions were not incorporated in either the 2015 or 2019 amendments. We have been through case law where parties with foreign awards, foreign emergency awards, have had to approach Indian courts under Section 9 of our Act to seek interim reliefs based on the award, but it is not actual execution of the award. We had 2 years ago in Amazon versus Future Retail, thankfully, again, Justice Nariman, who I think is the greatest boon to arbitration that India has had. Justice Nariman ruled that an emergency award that comes out of an India-seated arbitration will be enforceable because it will be treated as an award under Section 17 of our Act, which would treat the emergency arbitrator as an arbitrator under the Act. However, foreign awards, foreign emergency awards, are not enforceable as yet. And therefore, the first amendment I see that we need to put in place is in line with what the Law Commission and the High-Level Committee suggested. And a simple amendment was in the definition of an arbitral award, which definition includes an interim award, add the words emergency award. When you're talking about the definition of arbitral tribunal, which means a sole arbitrator or panel of arbitrators, include therein emergency arbitrator, so that you ensure that even foreign emergency awards are enforceable under Part 2 of the Act. Coming from looking at emergency awards, it made me really think of enforcement of interim orders of foreign-seated tribunals. Now, in India, interim orders of foreign-seated arbitral tribunals or in fact foreign courts are not enforceable? Should we not bring in an amendment similar to Article 17H of the 2006 amendments to the UNCITRAL model law, which, and I'm quoting from that, which says an interim measure issued by an arbitral tribunal shall be recognized as binding and enforced in a competent court irrespective of the country in which it was issued, subject, of course, to the grounds on which you may oppose enforcement. So two things: foreign emergency awards, foreign interim orders of foreign arbitral tribunals. And you can peg that, of course, with countries that have also signed the New York Convention, the same way you provide for enforcement of foreign awards. The third amendment, or maybe not amendment as such, maybe the introduction of some legislation or regulation, I think relates to third-party funding. And I think today it's a settled position in India that third-party funding is legal. But given that we are a country that regulates every sector, given that we are a country that is so wide, so diverse, where our population consists of the very sophisticated, the very rich, to absolutely not, where we have over 1,000 district courts, I think perhaps we do need to regulate third-party funding in some way. And therefore, the areas around which I thought regulation may be put in place would be in terms of the Arbitration Act. Perhaps we can include the types of cases which may be funded. An example would be to look at our Commercial Courts Act, which defines commercial disputes. So you have only commercial disputes that will be funded. You're protecting the unsophisticated parties. You're ensuring that only robust funders come in. So you have a definition for only commercial disputes. Then you have a specified value. Now, under the Commercial Courts Act, the threshold value is about 300,000. I think that's too low. I think it should go up. So you should have a minimum threshold value of, say, maybe 5 crores. So commercial disputes above a value of about 5 crores may be amenable to funding. Then I think we also need to have capital adequacy norms for funders. Now, this has been done in Hong Kong and in Singapore. In the UK, which has the voluntary code of conduct, which doesn't specify fixed capital adequacy norms, it nevertheless says that members should not make investment commitments without having adequate capital available. So keeping all of this in mind, keeping in mind that you don't want a fly-by-night small-time funder which is ultimately not able to pay up. Capital adequacy norms, I've just pegged it for now at 30 crores in my mind, because if you look at what Hong Kong and Singapore have done, it fluctuates between 20 crores in Hong Kong and 30 crores in Singapore. I've taken the upper value. Then disclosure of funding agreements. And I think that exists in most institutional rules and legislations where funding is expressly permitted. Disclosure of the existence of the funding agreement, but not necessarily the terms. Disclosure of any prior relationship between lawyers, arbitrators, and funders. That, interestingly, we already have in our Act, by virtue of the 5th and 7th schedules, which incorporate the IBA guidelines on conflict of interest. Then I think we also need an amendment in terms of confidentiality, so that the documents in an arbitration, which are required to be kept confidential, can be disclosed to a funder. So in terms of the Arbitration Act, I think these are the amendments that should be introduced. But thereafter, I would go further. Why not have appropriate amendments to the Commercial Courts Act so that you provide for funding of commercial disputes with maybe the same parameters? Amendments to the Insolvency and Bankruptcy Code. Now, the regulations already seem to permit funding where a company is under liquidation, but more clarity in that regard. Amendments to the Companies Act for what? For class actions, other actions for damages, and for oppression and mismanagement. Because as we all know, oppression and mismanagement issues today are not arbitrable. Let them be funded. I'm going to come to arbitrability, where I'm going to tell you I think we need to make some amendments there. Also amendments to the Consumer Protection Act, so that consumer actions and class actions which are permitted under the Consumer Protection Act can also be funded. And the fourth thing that I want to come to over here is arbitrability. I think Indian courts have hugely narrowed the scope of disputes which are arbitrable. We've seen what happened recently in Anupam Mittal, where the Bombay High Court refused to enforce an anti-suit injunction granted by the Singapore court because the underlying dispute was alleged to pertain to oppression and mismanagement. And of course, Darius appeared in that matter. So Darius, if you want to quickly comment on that. But instead of increasing the scope of arbitrability, which is a characteristic of a pro-arbitration jurisdiction, our courts have reduced it. And so maybe one of the amendments we could consider in the Arbitration Act is to say, for instance, notwithstanding any other law, any dispute which falls within the purview of a commercial dispute, and I touched upon that in terms of the Commercial Courts Act and third-party funding, may be referred to arbitration. We can make amendments in relation to fraud. And this was a suggestion of the Law Commission. The Law Commission had proposed that an arbitral tribunal shall have the power to make an award or give a ruling in relation to matters which deal with serious questions of fraud. Singapore permits it, the UK permits it, why should we not? And of course, oppression, mismanagement. And lastly, so for oppression mismanagement, perhaps you'll need to make amendments to the Companies Act, because under the Companies Act, the NCLT has exclusive jurisdiction. Maybe you put in a proviso to Section 430 to say that provided that disputes which arise under Sections 241 to 246 may then nevertheless be referred to arbitration by mutual agreement of the parties. Okay, I'm done. I think I've touched 10 minutes. The last thing I think, and the most important thing is, I think we are a pro-arbitration jurisdiction. I think our biggest problem is the delay in courts. And therefore, while it is not an amendment, I think the biggest thing the government can do is to have dedicated courts and dedicated benches to hear arbitration cases, not for one day of the week or 2 days every in the afternoon. Yeah. Oh, sorry. And one more, which I think we should do. There are 172 signatories to the New York Convention. We have only notified 50. It's an easy win to notify others that we do business with. Okay, thanks. Now I'm done.
No, thank you, Shaneen. You were well within your time, and it was so interesting to hear that your proposed amendments don't just pertain to the provisions of the Arbitration Act itself, but there's so much that can be done within the entire system to promote arbitration of other types of disputes as well in India. I think there'll be a lot of questions on that, but I'm also conscious of the time, and I'm also conscious of the fact that Darius has also said he has very interesting amendments to propose. So I'm going to pass on the mic to Darius, and then we'll see, time permitting, how we come back to the questions.
Thank you, Dilber.
Your time starts now, and I know you were very worried about the time.
Yep,
so
don't worry about that. Thank you, Dilber, and your team at MCIA, and of course, Shaneen. It was great hearing her, as always. I think Shaneen personified what happens to all of us, that we all say, let's start with a soft touch. Don't tinker with it. If it ain't broke, don't fix it. But then we do have a lot of ideas for how it can improve. And I think it's common ground that the 2015 amendments did set us on the correct course. And by and large, one has to say that India is a pro-arbitration jurisdiction, and things have gone considerably better after 2015 than they were in the years before. That said, there is always room for improvement, and no one should rest on their laurels. So if you had to scratch your head and figure out what you would now start doing, I have a few ideas. First of all, I totally agree with Shaneen someone has to take a long, hard look at arbitrability again. And by statutory amendment, bring in certain other areas. I won't get drawn into the oppression mismanagement controversy, but I would only say, and I don't say this is a partisan party, but I would say that the judgment of the Bombay High Court is exceedingly well written. I'd urge all of you to read it. Makes a lot of sense. Now, what I would do first is to look at the concept of parties to arbitration. And here there are two main areas which require focus. One is, of course, the group of companies doctrine. And that, of course, as you all know, has been the subject matter of a consideration by 5 judges of the Supreme Court, and their verdict is reserved. So I won't get too much into that. But I think it's safe to say that there are some guardrails that need to be now introduced either statutorily or judicially into the concept of group of companies. The second area which concerns parties is an area that we haven't addressed all the way from the year 2003. I think it's an ignored area. And that's the judgment of the Supreme Court in the Sukanya matter, which said that if you have an action, usually a suit, which involves both parties to an arbitration agreement and non-parties, you can't then bifurcate parties and causes of action, and the whole matter then has to proceed in the action and can't be sent to arbitration under Section 8. I think we need to relook at that. I think we need to now statutorily accept that a court can bifurcate an action before it, send the parties who are all parties to the arbitration agreement to arbitration, and let the suit continue for the remaining parties and the remainder of the cause of action. I think that sort of discretion has to be conferred upon a court. So that's the parties area. The second area, which I think again needs a relook, is Section 34. Now, I think on balance, the 2015 amendments did a wonderful thing by introducing a dualistic standard of review for one standard for purely domestic arbitrations, which is public policy and patent illegality, and another for international commercial arbitrations, which is strictly only public policy. And public policy with the caveat that any inquiry into public policy will not entail a review on the merits. Now, this was very important because around that time, the Supreme Court had been making a bit of a foray into looking at merits by introducing the perversity test. Now, I look askance at the introduction of the perversity test into our arbitration law because it's a principle from administrative law. And it doesn't respect party autonomy because it says, for example, if vital evidence has been ignored, then the award is perverse. Or if irrelevant evidence or material is taken into account, then too, the award is perverse. But how do you decide what is vital and what is irrelevant without getting into the merits? Now, this was part of public policy. After Sangyong, it became part of patent illegality. Whereas Section 34(2)(b) has a protection in the form of the explanation, which prohibits a review on merits, that will now apply only to the public policy part of the review. There is no similar guardrail for the patent illegality part. So you might well face situations where for purely domestic awards, where patent illegality arises, and that is now deemed to include perversity, a review on the merits is not statutorily barred by our Act. So I think that clarification needs to come in straight away, because otherwise floodgates can tend to open via the ground of perversity. The second area, now I have two other suggestions on 34. These are completely out of the box, and they're not essential, they're not necessary, but we need to start thinking about them. The first is, how do you ensure that a court restricts itself to the very narrow grounds under Section 34? And one of the ways is doing it is to adopt an instrument that is used under Section 100 of the CPC as regards second appeals, which are appeals strictly on a question of law, where the CPC itself says that a court will frame the specific issue or the specific question of law that it has to determine in that matter, of course, subject always to the discretion of the court to add further issues along the way. And then the hearing will be restricted to that issue. It might perhaps be a way forward to statutorily require a 34 court at the stage of admission of the petition to frame the exact issue that, in its opinion, arises under 34, whether under public policy or patent illegality. And quite obviously, that can't just be a reference to the broad head. It has to analyze that issue given the facts of the particular case before it. Now, there are two views on this. The view against it is, or you'll be putting in another rung or two for someone to challenge. But I don't think that would happen. I think our appellate courts in the Supreme Court is fairly disciplined. So I think it's a necessary guardrail to focus the attention of the court at the 34 stage. The last thing I would suggest on 34 is something very practical. I've seen many matters where a party essentially succeeds in an arbitration, but loses on one point of law or a patent illegality, which has the result of nullifying the whole award. And that's a completely severable part of the award. If the party ultimately succeeds in 34 in getting that part of the award set aside, it's a Pyrrhic victory because the whole award has to be set aside. It's not enough to set aside severably only that part, question of law, because that question of law determines the very relief you can grant in that matter, for example. So the whole award has to go and you're sent back to arbitration to restart the whole process of evidence, argument, etc. So perhaps a discretion should be given to the 34 court that in cases where the issue is completely severable and it thinks fit, if a part of the award alone is set aside, it can send the matter back either to the same tribunal, or in fact, it could even appoint a fresh tribunal to restart the matter from the stage it had left off. In other words, retain the evidence, retain the findings on all the other matters which are not set aside under 34, and only decide the point that is sent back. Something to think about, food for thought. It's something that I think is necessary given our system, which is a very litigious system where we tend to challenge every single award. So that's the 34 gamut that I would get into. One more completely unrelated amendment, which I think is necessary, is some recognition of bilateral investment treaty awards. Now, as you know, India is not a party to ICSID, which is the convention which gives direct enforceability to bilateral investment treaty awards across the world. Most countries or many leading countries are. We are not. In other words, a BIT award would have to be enforced under the New York Convention as a foreign award in India. Now, India, when it acceded to the New York Convention, included a caveat or a qualification saying it will only apply to matters that are commercial. It's the commercial qualification. Recently, the Delhi High Court has held that investment treaty arbitration awards cannot be considered to be commercial in nature. In other words, they would not qualify for enforcement under Part 2 of our Act via the New York Convention. Now, that means that an investment treaty award could be enforced in India only by means of filing of a suit on that award, which we all know is really not a remedy at all. So if we are interested in attracting investment and giving a fair remedy, I think it's necessary to amend our Act to clarify that an investment treaty award is nevertheless commercial in nature. And I think that's easily done because we tend to ignore the fact that the Commercial Courts Act treats disputes with the sovereign as commercial disputes. So there's no reason why the same principle couldn't be applied here. But the last thing I want to say is this. I think the real elephant in the room doesn't require a statutory amendment. It requires an amendment, or rather a transformation of approach. It's the way we lawyers practice arbitration. I think we have to, I've always said that the Indian lawyer is as talented and as good as anyone else in the world. And I've seen this in action. But we need to subject ourselves to international disciplines like time limits, accepting the IBA rules of evidence, no ambushing of opponents, strict checks procedures, things like that. And I think we have to now step up to that, because if we don't do that, there's no way that India will become an international hub of arbitration. But if we do that, we can transform India and thereby transform the very practice of arbitration, not only domestic, but also for international arbitration in India. And that will really make India a popular seat. We have all the other advantages. We have the legal talent. We have a pool of great arbitrators, including retired judges. We have English as a lingua franca of our disputes. We have a common law tradition over 150 years. So there's no reason why India shouldn't step up to the high table. So these are my few thoughts. Thanks very much. I hope I've stuck to my time.
Perfectly on time. No, thank you so much. I really wish the expert committee had joined this call, because your excellent recommendations that both of you have shared with us today. If I could just summarize really quickly, and my key takeaway from what both of you have said is that I think it really has to be a concerted effort between all the stakeholders, the judiciary, the executive, who needs to make certain diplomatic changes as well, the legislature, and the practitioners, who all have to sort of play their role in making India a full arbitration friendly jurisdiction. Each one has something that they can do as they can to work with. I see that we are running a bit over time, and as you know, I live in Switzerland, where time is extremely important. But maybe if there's just one or two questions from the audience, if anyone would like to ask something, feel free to put it into the chat if you like, or just raise your hand or turn your cameras on and your microphones on, and you have this opportunity to ask live or something now. If anyone wants to do that. If not, then what I would suggest is the next step that we were going to take is to break out into smaller sessions with a fewer participants in each group, and then we can maybe discuss in these smaller settings what we've just heard from Shaneen and Darius, and if somebody has further recommendations or ideas that they would like to share, then this can also be discussed in these smaller groups. So before we break out into these smaller groups, I just want to say thank you so much to Shaneen and Darius for taking time out of your busy schedule to be with us here today and share your thoughts on all these existing amendments to the Act. And thank you to all the participants who have also joined us. We have a resounding amount of participants for this first session. We're very happy. As I said, the YMCIA India Arbitration Talks is a webinar designed to bring the Indian arbitration community together in India, diaspora, abroad. If you have any recommendations, any suggestions, any topics that you would like us to cover, please drop me or anyone from the YMCIA committee a note, and we'll be happy to take this forward. So my last word before we break out into the breakout rooms. Thank you so much again.
Thank you.
Thank you.
Thanks a lot. Thanks to everyone.